Good afternoon. I'm Deborah Perlin, and I'm Director of Policy and Program at the American Constitution Society. Thank you for joining us today for our discussion, A More Perfect Union, the Future of Labor Law in a Post-COVID Economy. It's hard to believe that we have all been living through this pandemic for over 9 months. In that time, the fundamental nature of work has shifted, with over 25% of US adults saying they or someone in their household was laid off or lost their job because of the pandemic. Those that are still employed find themselves bifurcated between essential and inessential, workers who can telework and those that must risk its exposure and report to work every day. Sadly, these divides are often along racial lines, exacerbating structural racial inequalities that are built into American life. Although with recent vaccine news, there seems to be some light at the end of this very long pandemic tunnel, COVID has fundamentally changed our economy and the nature of work itself. As we think about rebuilding a post-COVID economy, what have we learned and how must labor law change to meet the needs of today's workforce? We have a wonderful panel of experts with us today who will talk about the roles that federal and state officials can play in guaranteeing workplace rights in a post-COVID economy and what we can do to build back better. Many of their materials can be found as CLA resources on ACS's website. To get this conversation started, I'm going to turn it over to today's moderator, Ruben Garcia. Ruben is a professor of law and co-director of the Workplace Law Program at the University of Nevada, Las Vegas, William S. Boyd School of Law, and a member of ACS's board of directors. His book, Marginal Workers: How Legal Fault Lines Divide Workers and Leave Them Without Protection, chronicles how minority workers, including workers of color, women, and immigrant workers, are often not protected by American labor law. Ruben? Ruben, I think you're muted.
Knew I wouldn't escape without happening. So welcome everyone. Thanks for being here. Thanks to our panelists for being here, and welcome so close to the holidays. I would want to start, of course, by again acknowledging ACS and its advocacy on these issues of worker justice and fairness in the workplace. And again, that's one of the reasons I'm proud to be a member of the ACS Board of Directors and Board of Academic Advisors. But as Deborah said, the COVID-19 pandemic has changed the world and continues to change the world as we speak. But before the pandemic, economic inequality was already a widely recognized problem. Now, after the pandemic or during the pandemic, the gap has grown even wider with farm workers, grocery workers, and healthcare workers doing essential work but not yet getting essential wages. Before the pandemic, employers were able to monitor their workers through a number of different technological devices. Now, within the workplace, now with everyone working at home, the workplace has extended into the home with total awareness surveillance of employees being used now in order to engage in a number of employer prerogatives such as busting unions. Before the pandemic, we had a labor law that was outdated after 85 years of technological change and the fine-tuning of employer attorney strategies of union avoidance. Now we have the same, even more obsolescence in a post-pandemic world with our NLRB showing the same suspicion of mail-in balloting that our current president has. But some things have not changed, and that has been the willingness of workers to join together in these extremely hard times and fight for better protections, more PPE, and legislative protections. So there are numerous examples of that kind of advocacy, but we're going to hear some today from our wonderful panelists. And I hope when we get to questions, we will hear more stories from our audience members. So with a new administration starting in Washington on January 20th, and a newly emboldened conservative majority on the US Supreme Court, it seems like a good time to take stock of rethinking labor law in the next era. So let's start with our panelists and what they are doing and thinking about in order to meet the moment. We'll start in alphabetical order today with Nicole Berner, the General Counsel of the Service Employees International Union, and a former member rotated off the board of directors of the American Constitution Society. And she'll talk to us right now about homework or care work and how the SEIU and its allies are working to meet the challenges of COVID-19 right now in their union. So, Nicole?
Thank you, Ruben, and to ACS for putting together this important panel. I said before we began that I was surprised we would have anybody logging in on December 22nd, 2021, but I'm excited to see that we have more than 125 participants zooming in, and I appreciate all of your interest in this really important topic. The framing of this is so important that workers, essential workers, have really always been essential, and the fault lines and the cracks in our system, our legal system around labor law have always been there. But the pandemic and the multiple crises that we're facing have really laid it all bare in front of us. For those of you who are not familiar with the Service Employees International Union, we are a union of more than 2 million members in the United States, Puerto Rico, and Canada. Our membership is both in the public sector and in the private sector. Half of our members are, 1 million of our members are public sector workers in state, local, and federal government, and half work in the private sector, half work in healthcare. So our members have been on the front lines in home care settings, nursing homes, and hospitals. And we also represent janitors who, of course, have been on the front lines, security guards, and of course, public services workers who have had to work through the pandemic. So we've been living through one of the most uncertain times in more than a century. And I don't have to tell you that working people face multiple crises, not just the pandemic, but they face a rigged economy that works for only the very few at the top. We faced unprecedented attacks on our democracy and voting rights. And we've seen that bear out in the past few months. Systemic racism that has always been part of the history of our country, but has been laid bare by recent events. And there's been an increasing loud conversation about it in our country that has been so important. And of course, catastrophic climate change, fires and hurricanes that we are suffering from. And so all of these multiple crises, people of color, immigrants, and women of all races have really shouldered most of the essential frontline work during this time and continue to really face a particularly heavy burden. These crises are intersectional and they feed upon one another, so that as we've seen a healthcare crisis and a racial justice crisis, they are intersectional and they feed upon one another, as we've seen a climate crisis and a crisis around democracy. Those intersect as well with the pandemic and racial justice. And they are structural problems, and they call for structural solutions. And so while we are, of course, we were glad to see last night a vote on another relief package. That relief package, which gave some relief to those who are suffering, it didn't give enough. And in particular, there was no relief for state and local governments that are suffering really from an unprecedented economic crisis, and where public sector workers who rely on public funding, which has been so diminished by this crisis, got no relief from that package last night. So we do need labor law reform, and the labor law reform must put workers at the center, and I think particularly the workers that have been left out. We need sector-wide solutions, and there's been a lot of talk of massive government relief efforts that are going to be needed to address these multiple crises. So whether it's talk of the Green New Deal or talk of structural change to our healthcare system, it's our belief that all government funding must be contingent upon the creation and the protection of good jobs. Government funding should not fund bad jobs, and it should not make the economic crisis facing workers worse. Rather, we should use government funding to improve workers' lives. Every worker should have a living wage. $15 an hour should be the minimum. And workers also need a right to join a union, a real right to join a union, to organize and to bargain to improve and maintain their working conditions. So the multiple crises, I believe, have really exposed the best and the worst of our country. We've seen just how much we depend on one another. And no matter who we are or where we're from or what is the color of our skin, this crisis has demonstrated in a real way that we need each other, that we rely on each other. And it's also revealed the deep cracks and divides that have always existed. I want to focus on our care system, and I actually put into the materials for the CLE a piece that we produced together. You should have it with the National Domestic Workers Alliance around the importance of care work in our economy and the changes that we hope to see in the care economy. But really the proposals that are in that document that you should have available to you really apply across the board to all workforces. We need essential workers that are providing essential services need to be protected and respected and paid. And so it's on those three principles, protection and respect and pay, that I want to talk about care. So when I talk about care work, I talk about workers caring for the sick and the young and the elderly, workers that are cleaning homes, of course, and helping those in our society that are the most in need. And President-elect Biden has addressed this care crisis as part of his Build Back Better plan in talking about care workers, not only as essential workers, but really as care workers who are a job that has been historically a job that has been left out of labor law. As Ruben said, care work, it was left out of the Fair Labor Standards Act originally. It was left out of the NLRA. And this wasn't a coincidence, of course, because these were jobs that have historically been done by women, by people of color, and by immigrants. And those jobs were carved out of our labor laws, and we need to remedy that. And so there has to be a recognition of the importance of care work and an investment in care work. And the care crisis in this country already existed before the pandemic, but it's only been exacerbated. And so we need a real breakthrough for long-term care. These jobs, these long-term care jobs, need to become good jobs, and they need to form the foundation of an inclusive and multiracial middle class. There are at least 12 million seniors and people with disabilities that need long-term care services in our country. And with the aging of our population, this is the fastest growing job in America. And we've seen the high proportion of deaths in congregate care settings, especially in nursing homes. And this has really only heightened the need to create a structure in which care work, the people can stay in their homes and be cared for in their homes. And so there needs to be investment in this care infrastructure. It needs to be part of the plan to build back. And we need to have improvements into our care workforce. So we need a home care program that is designed to recognize the nature of the workforce. It should build on existing models for care. And it should ensure that these taxpayer-funded jobs, because care work is taxpayer-funded work for the most part, are good jobs, again, that pay at least $15 an hour, and where workers have the right to form a union, a real right to form a union. And the federal government must ensure that all taxpayer dollars are creating good jobs. And so as we see taxpayer dollars going for healthcare, taxpayer dollars going for improvements to infrastructure, taxpayer dollars going for addressing the climate crisis, all these investments of public funds must include a requirement that the recipients enforce high standards for everyone receiving government contracts, and that workers are paid a living wage and they don't contribute or exacerbate the economic divide, but rather seek to remedy the economic divide. So again, I wanted to share with you our vision and our hope and our work with the president-elect and the new administration around care work because of the importance of care in the pandemic. But it's just one example of the kinds of changes that can be brought about for workers through, in particular, the use of government funding as a way to influence the kinds of jobs that we have in this country, the protections the workers get, the respect, and the pay. And with that, I'll turn it over to the next B on our panel.
Thank you, Nicole. And thank you for, again, going through that legacy of exclusion that I know we're going to talk about and what its implications are for the future. We're going to talk about in the rest of the panel. But now we'd like to turn to Sharon Block, Executive Director of the Labor and Work-Life Program at Harvard Law School, who has held a number of policy positions throughout her career in Congress, at the National Labor Relations Board, and in the Department of Labor. And so over the last few years, she has taken that experience to Harvard to spearhead or co-spearhead, as the case may be, the Clean Slate for Labor Law Reform Project. And I've been it's a collection of nearly 100 activists, advocates, and academics. And I was very glad to be part of that. And there are a lot of ideas in that project that are particularly relevant and pertinent for the time we're in right now. And so I know Sharon will have a lot to talk about in terms of, again, where we are currently in rethinking labor law and where we might be going in the future. So Sharon?
Great. Well, thank you so much, Ruben. Thanks to ACS for including me in this amazing panel. I can't think of three people whose opinion on these subjects I respect more. So I'm very pleased to be with all of you. And as Ruben said, Ruben and Nicole especially were really key parts of the Clean Slate project. So it's great to be with you again. So I'll step back and just explain a little bit more about what the Clean Slate project continues. It's been going on for a couple of years. I'm definitely a co-leader of it with my colleague here at Harvard Law School, Ben Sachs, who's taught labor law here at Harvard for a long time. And the project was born out of a belief that we are experiencing a dual crisis of economic and political inequality that really has the potential, if not already the reality, of sort of undermining the stability of our economy and social order in our country. And the role that labor law can play in being a part of solving those dual crises. Clearly, labor law reform is not the only answer. Even in the realm of labor, it's not the only answer. This is very, very complex problems, but we do think that labor law is an obstacle, as it is now in our country, is an obstacle, despite its origins as a means to allow workers to build organizations, empowering organizations. It has in fact become an obstacle to that, and that the ability of workers to come together and create organizations that can countervail the power of corporations, that we are not going to solve these problems unless workers have that ability. Again, we remove these obstacles. And so we launched this program with, as Ruben said, about close to 100 participants over the course of about 2 years to look at different aspects of labor law. We sort of bled outside of labor law a little bit, but the driving ambition of the project was to create a long-term but not completely fanciful vision of what a labor law that was designed to empower workers could look like, and to think about that sort of from the ground up in terms of the legal infrastructure. So to create this new legal infrastructure for empowering workers, and that as we engaged with this amazing group of people from really all over the world, we had a group of international advisors, in addition to, as Ruben said, union leaders, academics, economists, workers, activists, advocates, students, futurists, technologists, that it was important to think about finding ways that workers could build power at every level at which corporate power impacts workers' lives. And so we came up almost a year ago, 11 months ago, with a report with an initial set of recommendations to create this big vision of a new labor law. And I'm happy during Q&A to go into the elements of it in more detail as people are interested in, but just to give you sort of the broad outlines. We start with inclusion, that the idea that everybody, all workers, no matter how they're classified, what their occupation is, that they have the opportunity to have the law's protection to build powerful work organizations. I think a bedrock of building powerful worker organizations is workplace organizing, of building the solidarity from the ground up, which is in a very imperfect form, the basis of our labor law today, but that you also, this is an and, not an either or, that there needs to be sort of an umbrella over that workplace level organizing of sectoral bargaining to create a higher level of impact for workers in affecting the economy. Workers need to be able to have meaningful collective action. Our law, in fact, now diminishes the ability of workers to come together to think strategically about how to exercise power if they're able to amass that power. So that needs to change. Workers need a role in corporate decision-making. We include recommendations on workers on corporate boards and expansion of the kinds of decisions that workers have a right to bargain over. We need changes in democratic participation, again, to remove obstacles to workers participating in sort of the mechanics of democracy. And that we can't let ourselves get in this place again of what many call an ossified labor law. And so that part of that is allowing innovation at the state and local level. So that was a year ago. I think the events of this past year have really borne out a lot of the basic premises of the Clean Slate Project. And so I just want to talk just a little bit about sort of how we see the Clean Slate vision for labor law playing out through those crises that Nicole described so well. So first in COVID, obviously we have seen the devastating effects of what happens when too few workers have a voice in decision-making. Workers were subject to decisions made by companies about how to deal with the pandemic that left all too many of them too vulnerable to the exposure in the workplace or to economic devastation. And just for a point of comparison, in countries with strong sectoral bargaining systems, I mean, obviously workers around the world have been devastated by this pandemic, but we did see in those countries a structure in place where unions, employers, and the government could come together much more quickly to come up with strategies that were more protective of both the workers' lives and livelihoods, something that just too few American workers had. We've also seen in our COVID experience what happens, how non-responsive our political system is to the interests of workers when the labor movement is not strong enough to exert, to countervail that corporate power. You end up with things like a paid leave program that excludes companies that have more than 500 workers. As Nicole mentioned, you get the kind of relief that passed this week that is welcome, but not enough. Around the racial justice crisis reckoning that the country has gone through this year, in Clean Slate, we really tried to see our recommendations through this lens of addressing racial and gender injustice, not just in terms of the obvious, the exclusions, the explicit racist and sexist exclusions from the NLRA, from the right to collective bargaining, but how in building a new legal structure that you have to look at every aspect of that system and how it addresses these this history of racial and gender injustice. And then looking at the outcome of the presidential election, I don't think that any of us involved in Clean Slate were naive enough to think that had there been a big wave election behind Joe Biden's ascension to the presidency, that clean slate would be, moving itself onto the Senate floor. But clearly with the Senate that we are likely to have, I think even just whatever the results are in Georgia, that this idea of having this kind of fundamental labor law reform is a long-term project. Towards that end, one thing we've done this year in Clean Slate is give out a number of grants to groups at the state and local level who are trying to make change in the spirit of Clean Slate to keep that that innovation going where it is possible. It's difficult under our legal structures, but we have groups, we've given grants to groups that are working on things like just cause, sectoral bargaining for groups who are outside of the NLRA. We're working on digital organizing strategies, worker-owned cooperatives. And so we hope to keep momentum going as we continue to try to make the case for fundamental labor law reform.
Thanks, Sharon. And we are going to talk, of course, a bit more about specific ideas and recommendations of the project, and maybe what's even possible given no change in labor law, which is certainly also possible for a while. And also, you mentioned again the relationship or the fact that a lot of what happens, of course, we think about as federal law, and federal law is very preemptive of a lot of what states can do in the, at least in the collective bargaining space. But we now have Renika Moore, director of the ACLU Racial Justice Project now, who has also done work in the New York Office of Attorney General, and so knows a little bit about those state and local possibilities and those tools that might be available even given no change at the federal level. And Renika uses litigation, advocacy, and grassroots mobilization to address some of the barriers to racial equality that we've been talking about, again, in these various exclusions, and then what might be possible given, again, where we are, and particularly the heavy impact that COVID has had on communities of color and immigrant communities. So Renika, would you like to take it away?
Sure, thank you. So I'm going to talk spend most of my time talking about my experience leading the Labor Bureau at the New York Attorney General's office. And so, I took over that Labor Bureau from Terry Gerstein, who now works with Sharon Block. And the New York Attorney General's office has a legacy starting with Tricia Smith, who was also at the U.S. Department of Labor as a Solicitor General. And there was just a strong commitment in the office and with that department to ensure we were strengthening and maintaining kind of worker gains that were accomplished through worker organizing. And so the focus was really, during my time, we were really focused on how to ensure that wins that we secured through our investigations. And the New York Attorney General Labor Bureau had both criminal and civil enforcement authority. And we were able to use that along with subpoena power to investigate employers and labor violations. And we were also able to work across the office with other areas of expertise. And I think it's important to be aware of kind of the powers of state attorney generals as we look forward and we look to the future and see how they've worked during this period of COVID. So I'll use a couple of investigations that we had as examples of what we were able to do. So there were a couple of worker organizing campaigns that were going on in the car wash sector, and that we were able to engage in investigations. One investigation in particular that I think is illustrative of what, as an attorney general's office, we were able to bring. Workers were claiming that they were not being paid for all their hours worked. They were working to organize and be recognized as a collective bargaining unit. And what they determined was that they were being denied their wages, but they were also being divided along racial and ethnic lines, which was really making it difficult for them to be able to get the information they needed from the employer in terms of time cards, key information about how the business was run. And so we were able, through the use of our subpoena power, to obtain both witness testimony from the car wash manager, which indicated, for example, how many workers were supposed to work at the car wash. And, the manager testified that even on the slowest days, that there were at least 20 workers in the car wash. And what we determined through our investigation and subpoena of documents is that the time cards, when we were able to analyze them with our analytics team, that the time cards showed that there were workers who were not being recorded, and that when we looked at the hours on paper, what the allegations were was that the employer was requiring workers to clock out or was denying them access to their time cards as they approached the end of the work week to avoid paying overtime. So as they approached 40 hours, they would remove the time cards. And so what we were able to show through the investigation is that for the end of the work week, you were seeing the time cards suggested that there were only 2 workers in the car wash at some of the lowest rates, and that the hours being clocked simply weren't even enough to operate the business. And so the employer was clearly denying workers the ability to fully record their hours. And we were also able to provide confidentiality protection during the course of the investigation because as the Attorney General, we are not required to disclose how we've obtained our information unless and until we file litigation in court or the investigation is resolved. And so we were able to do our investigation in a way that didn't jeopardize the identity of workers who were not yet sure whether they wanted to participate, in part due to concerns about immigration status and retaliation. And then we were able to conduct other investigations around, for example, home health aides. And in those investigations, we were able to work closely with the Healthcare Bureau in the Attorney General's office and to understand the industry and use the different parts of the office and expertise to be able to prove in our home health aid investigation that workers weren't really being allowed to get the mandated time off. So when we had workers who were home health aides who were working 24-hour shifts and were required by law to be allowed to sleep, to get at least 8 hours of sleep and 3 hours of mealtime. And what we were able to determine through the care that they had to provide to patients, that many of the patients required care that meant that they had to attend to them every 1 to 2 hours. And so there's just no way, given what the patients they were taking care of needed, that they were getting the required amount of sleep and rest that they needed. And they weren't being paid for the time that they were performing that work. And so there were a number of different ways that we were able to use our investigatory authority and our power, as well as the expertise and resources of the other parts of the office to do a more robust investigation that workers themselves would not have been able to do, and that litigation alone by private litigants wouldn't have been able to accomplish. And we were able to look at problems from multiple perspectives. So at one point we were looking into nail salons, and there were certain kind of environmental worker safety issues, and we were able to call on our Environmental Protection Bureau within the state AG's office to consult with and to rely on as experts. And so to the extent that you have a state AG offices, it's important to understand sort of what their authority is, what their power is, and how they might be able to assist and support efforts of workers, as we were able to do. And one of the other pieces that has carried over into my current work now with the ACLU leading the racial justice program is also really looking at the role of technology in workers. And I think both Nicole and Sharon have talked about this, and Ruben started off talking about the ways in which technology is changing the way that workers work. And in my current work, we've been looking at the role of AI and algorithms in everything from surveilling workers to determining worker schedules to hiring and promotions. And so within the last few months, we put together with a coalition of civil rights organizations guidelines for how to use, for example, hiring algorithms, and to really ensure that they are not discriminating against both racially, historically marginalized groups, but also disabled applicants, language minorities, and various different constituencies that are often left out. And then we're thinking about transparency thinking about the role of AI technologies and the extent to which they, it's clear what specific technologies are supposed to do. And so in the case of hiring technology, that is actually job related and tied to the work that it claims to be hiring workers for, that it includes certain auditing and reporting functions to ensure that not only as tested that the technology does what it says it's supposed to do, but on an ongoing basis, there's continued recording and reporting of what the impact of particular AI and algorithmic systems are. And then thinking about notice and explanation to workers so that those who are being subjected to algorithmic technologies understand when they are in fact being subjected to any kind of process, and explaining what their recourse is to the extent they want to challenge a hiring decision or promotion decision. And then the last piece of that also goes back to the role of state and federal regulators and enforcement authorities is really to think about oversight and accountability. And so we've been thinking through what are the roles that government can play, whether that's Department of Labor that might be a primary regulator, or the role of Attorney General's offices, which tend to play a more strategic role in thinking about where they can bring enforcement actions and investigate. And that can happen at the state, federal, and local level. Because even at my time at the New York Attorney General's office, we regularly worked with and partnered with New York City regulators. And then we were able, obviously, New York State and New York City have pretty large resources. They're generally speaking a fairly well-organized, labor-friendly environment. But we were able to work with other parts of the state when I was in the state attorney general's office as well, and in parts of the state that didn't have the same kind of robust protections. And so that's another piece to be thinking about when working with attorney general's offices. So as we think about what is the role and how we look forward, I think state attorney generals can play an important part. And now that I'm back in the nonprofit sector, there's a role of oversight and pushing for these governments and advocacy to ensure that they're really responding to the very real conditions that workers face, and how we can ensure accountability and real progress in light of all that we've seen this year. For all the bad that there's been this year, the uprising and the power of collective action has been shown time and time again in the policing context, I think in the worker safety context, in the role of technology and the ability of it to be used both to advance worker protections and to bring us to a better place, but potentially to also stifle collective voices and stifle workers. So we need to be thinking about how both to regulate and empower on both those fronts. And I'll stop there and turn it back to Ruben.
Thanks, Renika. I thank you all. And I just wanted to make a couple of housekeeping announcements. One, just to remind you that you can put questions into the Q&A, and I'm going to start with, I've already gotten a couple of questions in the Q&A that I'll be going to in a minute, but the Q&A is there for you. And also the link to the materials for this program were put in the chat. So there's a number of articles there, again, you can check out. And I think it, including, some articles about the way that, technology is being used or abused to limit labor rights. And we know, of course, that there is some regulation of that already, at least, in the old, in the before times, you'd have certain anti-surveillance kind of rulings or anti-surveillance laws that limited the use of worker activities to cut back on their right to engage in concerted activity. But now we have very sophisticated, as Renika was touching on, we have very sophisticated tools involving AI and sort of heat maps and otherwise that employers are using to try and monitor workers, not just in their organizing activities, but also their what else they're doing, quote, at home. So I guess I would ask the panelists to kind of take a go with that question, sort of what are they seeing out there in terms of employer tactics, and then kind of touching on, or going back to Renika's last point. So how are workers using technology, or what are the ways that workers can use technology to kind of also organize or engage this moment when so many of them are dispersed and have a hard time congregating. I don't know if Nicole, do you want to start with that, and then we can go through?
Well, workers needing to communicate with one another is something that's been a problem that existed before the pandemic. Again, I think the pandemic has actually in some ways given us, made us all aware of tools that we have to communicate even when we can't be together. Employers have the ability in work sites to control employee communication with one another, even in spite of prohibitions of labor law against interfering with worker communications with one another. I mean, this is something that one of the concerns about the National Labor Relations Act and the fact that it has the enforcement teeth are so dull that even though the act protects workers' communication with one another, workers are often face retaliation and even termination when they attempt to do so. And so whether it's communicating with one another on workplace email or using other ways to communicate, it's been a problem that we see when we're trying to organize workers. And then of course, many low-wage workers don't have a work site. And I think about our home care workers, once again, that I spoke about earlier in the panel, and how literally each and every worker is in a separate work site. And many also speak different languages from one another. So there are language equity issues. And yet through their union specifically, they're able to come together and form a really powerful voice for change for themselves and for the people they care for, and frankly, for the whole system that they advocate for through changes to the long-term care system. I think what's been really interesting about this time is the ways in which workers have been able to innovate in coming together to protest for the personal protective equipment that they need. I think about workers in nursing homes who have gone on strike in this time that has been really the most frightening time to go on strike, and yet they have gone out on strike in Detroit and Chicago and been able to improve their working conditions. And they've done so in car caravans and in socially distanced protests. Social media has played a huge role in allowing folks to communicate with one another through this time. I know that it's been surprising to me to see the extent to which fast food workers who have not yet been able to organize into unions on scale, again, because of the limitations of our labor law, and a workforce that have been essential, have had to go to work, have been terribly at risk, have been able to take advantage of organizing through social media platforms and communicate with one another about what's been happening at their workplaces around the country. And again, I would say that the efforts to suppress worker communication are not new. I think oftentimes we think about new technologies as some change, and I think that whether it was tearing down flyers on bulletin boards or surveilling workers' emails, those are all symptoms of a system that is broken, that doesn't sufficiently protect workers, that needs to be modernized and strengthened and brought into the 21st century to encompass the entire workforce. The other workforce that I want to mention is what we call quote unquote gig economy workers. Of course, many of whom, whether it's, I think probably a lot of folks on this Zoom rely on every day to shop for them in Instacart, to bring them food to their homes with DoorDash. And these are workers that have, again, had to work through the pandemic without any protection of our labor and employment laws because they're not in most places classified as employees, and so have been without protections, without the ability to form a union, without personal protective equipment being provided to them. And again, we all rely on them as essential workers. We have seen they're now, called essential, but not treated as essential. And so that's another workforce that, there have always been gig workers. They've always been misclassified. This is the new version of that. And we need labor laws that will encompass every worker and give every worker protection and the right to a union.
Thanks, Nicole. And Sharon, are there particular recommendations along this line in terms of technological tools that workers could have to better organize in this moment, particularly after the pandemic?
Absolutely. I mean, we did make recommendations in Clean Slate around creating safe digital spaces for workers to be able to communicate with each other, to organize, to protect from the kind of surveillance that, at least when the NLRA is being interpreted properly through the worker protective lens that I think it's supposed to be, protects from that physical surveillance, extending that and strengthening those kinds of ideas, just as Nicole was describing, to a digital sphere. The other piece, and I can't build on, Nicole did a great job of sort of describing this this moment. The other piece I would mention, though, is also, I think, what we're learning more and more about in this this more technologically driven economy and environment that we're in is just the incredible information asymmetries, right? If the amount of information that employers are able to amass about their workforces and how little of that the law compels them to share with workers is really a great, again, another impediment to effective organizing. And so in Clean Slate, we also have recommendations about the need to share more information, disclosures, so that there can be more effective and strategic use of information by workers who want to organize.
And I'll just add, I think the one upside of this moment is that many workers are armed with their own surveillance cameras themselves and with their own. And so we've seen really creative uses of even with just the phone. And I completely agree with Sharon's point that the information asymmetry is staggering. But we are seeing workers use, cameras, use video to share with the world that which we would have otherwise, been relying on just testimony or accounts that just don't have the same compelling kind of imagery. And so we've seen Amazon workers showing their workplaces and just the lack of PPE and the lack of measures take to Twitter and other social media campaigns and really to connect with each other. We've seen workers in lots of other industries being able to show in real time kind of the conditions that they're working under. And I think that is not to be understated. These power asymmetries have always existed, but there have been really creative uses and deployments of what the tools that are available. And there are ways in which folks have been able, I know when I was at the state AG's office, we worked with and talked with like coworker.org and some of the other platforms that allow workers to connect, even workers who are not employees. So that can mean across franchises and across gig worker situations where they might not otherwise have access to each other. And so you see, as always, you're seeing workers be creative in figuring out how to overcome some of the structural barriers that divide them from each other, or the spatial barriers in the case of the home health sector. And so the important thing is for us to also be aware of those, and for regulators to be aware of and support and protect those to the extent that we can, and advance those as well. I just wanted to add that piece about the ability to kind of push back and the creativity we're seeing workers address this problem.
Great, thank you, Renika. I just remind you that around the audience that we have space for questions in the Q&A. We have time for about 10 more minutes for questions, and we have received a couple, and they both asked the panelists to comment on essentially on both the future of labor arbitration, but also the future of, or the possibility of interest arbitration, that is in a negotiation that's gone bad, having an arbitrator basically make a decision to conclude the agreement of the parties. But that, is a something that doesn't exist in the private sector at this point, but has been proposed as a remedy for recalcitrant employers in the PRO Act, which is pending in Congress now. And so I guess the question, both questions kind of ask about what the future, both of the use of arbitration is in the future, but also the the possibility of greater remedies or greater strength, more teeth, as we were saying, for the NLRB to actually bring to bear on recalcitrant or basically law breaking private employers. Does anyone want to take a stab at that?
I'm happy to. I mean, I think that the inclusion of the arbitration provision in the PRO Act is important. I haven't looked at this in a long time, and I wonder if these numbers have been updated, but there are just an incredible number of or new bargaining units that never get to a first contract. And obviously, if you can't do that, then it's not hard to see why decertification can follow quickly on. On the question of penalties, it has to change, right? It won't matter if you change the sort of substance of labor law if we continue to have a law where the price of penalties can be easily absorbed as a cost of doing business. And that's really where we are now. And so I think the PRO Act's provisions to greatly increase penalties, sends an important signal that this law is meaningful and that the government and Congress expects employers to follow it, and hopefully, then spurs better behavior, because we don't have, the penalties do not provide a deterrent effect at all. You're really relying, or very minimal, you're really relying on the goodwill of the employer to follow the law at this point. I don't think that's too much of an exaggeration.
Anyone else want to comment on that?
I would say also the fact that we have such low union density in the private sector now in this country, below 7%, as I understand it in the last studies, makes any kind of arbitration and collective bargaining more challenging because of the structural problems with our labor laws. Employers are able to engage in union busting activities that make it very difficult for workers to form a union and then to maintain their union rights and prevail in collective bargaining. And so until unions are strengthened and more workers have the ability to form a union, and there are stronger penalties and disincentives to union busting, I think any type of collective bargaining, even with interest arbitration, mandatory arbitration, will be difficult. If it's okay, I wanted to address Corbett Anderson's question in the chat about government procurement power and executive authority. I think, of course, in order to get any labor law passed, we would need to have a majority in Congress vote. And I think barring, I think we're all hoping to have a progressive majority in the Senate and the House who would vote for labor law reform. But even without that, there are actions that President-elect Biden can take, and procurement power is a huge power of the government. And that is what I was talking about in my opening about the use of executive authority over the government's procurement power, particularly in service contracts, and in the use of procurement power for healthcare contracts in order to influence and really mandate responsible employer policies. And so the answer to you, Mr. Anderson, in your question is yes, absolutely. President-elect Biden can and should use executive authority to issue executive orders to protect workers, to make sure that their workers, any worker that is paid with federal dollars, is paid a wage that that worker can live on and has all of their rights protected under federal law. And so we are working on pushing for executive orders around procurement, and also executive orders around other issues, including long-term care that I talked about earlier. So the president can act, and we have every expectation will act to protect workers and to make that a first priority after January 21st.
Thanks. Renika, a couple of questions, or you could also kind of maybe speak perhaps to the state use of procurement powers, but also the question of whether the importance of the political party of the AG to investigate issues related to labor violations, and how important it is, again, to have someone in the AG's office that is willing to actually follow up on those labor problems. Could you talk about that?
Sure. I mean, I think the one variable that is not specific to party is just in terms of the authority, the general scope of the authority of the Attorney General in that state. And there are a wide range of options. Certainly when I was at the Attorney General's office, we worked with many states, and depending on the issue, I worked under 2 Democratic Attorney Generals, and we definitely worked most often with other Democratic Attorney Generals, but we did work across the aisle with Attorney Generals broadly, to the extent we were dealing with issues that really addressed basic kind of either access to the labor markets or workplace. So for example, our work, when we were doing work around no poach agreements, we were able to work with some Attorney General offices that were led by Republican Attorney Generals. And I think in terms of the procurement power, in state Attorney Generals, that can vary in terms of how exactly that's handled at the state level. So it is not always entirely within the control of the Attorney General's office. I think there is an advisory. The Attorney General in almost every state serves as the attorney for agencies within the Bureau, and the purchasing power of the state. They can offer up advice and counsel that will push toward more opportunities and more equity and diversity in terms of how those procurement powers are administered. But sometimes the actual authority for the Attorney General is a bit more limited. And I think, though, where many states can come in, many state AGs, regardless of the authority they have, they can also weigh in terms of either amicus briefs or in terms of statements of support and just the bully pulpit, and using that bully pulpit as well. And I think we, in terms of worker safety, in areas that intersect with consumer protection, which is generally like a much more kind of less party specific aspect of Attorney General work. Those may be areas where really pushing for safety. And so we were able to do some work around protecting for hire drivers, for instance, and ensuring that they were the pricing models and the pay models that would otherwise be employment issues are maybe treated as consumer issues. And so just thinking creatively about how even where workers are not being classified as traditional employees under most laws, there may be other ways in which you can use the regulation through the the tax function, tax oversight functions, or the consumer protection functions to protect and do what's best, not just for workers, but often for end users and end customers. So those are some of the ways to think about those powers.
Thank you. Well, we're almost out of time. We have some great questions in the chat about how the tide might be turned at the NLRB, and what's the future for or the place of worker centers in the future of organizing. These are all great questions, again, that we could talk about at length. I guess I'll just go with lightning round to the panelists and say, what is it, what stories or movements are you seeing that give you hope in these last minute or so? Any hopeful stories out there?
All right, I'll bite. I'm really excited. One of our grantees for our Clean Slate grants this year is working on a Just Cause campaign And I think that's really interesting. I think just not very long ago, people would have thought that was crazy to be talking about just cause or pushing just cause, and it's actually happened, right, in Philadelphia in the parking attendant sector. And so I think I find that hopeful, one, because I think just cause is really important, but also just to show sort of the vision and the courage of groups on the ground to take on issues that they think are important, even if they're, they seem too far down the line or too outside of like what polite company is willing to talk about.
Yeah, and I'll just piggyback on that, Sharon, and Terry Gerstein just put in the chat that New York City just passed just cause for fast food workers. And I was going to add that I'm really inspired by the organizing and mobilizing of fast food workers all over the country and the courage to strike, even in these really difficult times. And particularly the intersections of race, of the racial justice and economic justice and healthcare justice that the fast food fight really lays bare for all of us. And they have been victorious in court as well in getting injunctions against McDonald's stores that have been failing to provide PPE for workers who have become in shops, particularly where there's been COVID outbreaks. So that's been an inspiration for me in these times. And also, of course, all of the healthcare workers that are on the front lines and fighting for their own safety and the safety in their communities. And I just, as we go into the holidays and this surge is increasing, I can't let this end without giving a shout out to all of the folks who are protecting us every day.
And I think my initial answers have been taken, but I'll add, in terms of our food service workers and just the creativity, again, we're seeing around how to organize even in the face of, a fissured workplace and the fractures within the workplace. Folks are using many different opportunities to organize and to gather support and following from customers and other ways, and to tap into, I think, a desire to really step up and do the work that needs to be done, and to find unusual allies. And so I think we've seen that in terms of pre-COVID, but also post-COVID, the high road workers and some of the work that's done around the Restaurant Opportunity Center, and some of these other ways. And there's still so much more to do, but I think we can be encouraged by the creativity and persistence of workers.
Thanks to the panelists who've all given me something to be hopeful for. And I'm hopeful, I'm very glad to see 116 participants on this. That's also a great source of hope. So thanks to Deborah and to ACS for putting this on.
Well, thank you so much to all of our panelists, to Nicole, Sharon, Renika, as well as to Ruben for moderating this conversation. For those who are interested in learning more or getting CLE credit for today's discussion, please visit our website at www.acslaw.org. Thank you for joining us, and best wishes to all of you for a safe and healthy new year.